Let's call this meeting to order of the House Committee on Judiciary and Hawaiian Affairs. It is 2 p.m. Wednesday, April 3rd, in conference room 325. We are here for the purposes of hearing testimony on numerous measures and making decision-making. For those who are testifying today, I would request that you keep it to 2 minutes for your testimony. I'll ask you to wrap up. If you're testifying via Zoom, please keep yourself muted and your video off while waiting to testify and after your testimony is complete. Use the Zoom chat function if you've got technical issues, and our staff will help you out. If you're disconnected, don't panic. Just rejoin when you can, and I'll try to fit you in to provide your testimony at that time. If there's a network failure or power outage here in the Capitol, we may have to reschedule, and I'll make sure to post appropriate notice. If you're testifying on Zoom, please avoid using trademarked or copyrighted images. And everyone who's testifying, please refrain from profanity or uncivil behavior. Please, it's okay to disagree, but let's not be disagreeable. First up, we have Senate Bill 2245, Senate Draft 1, House Draft 1, relating to the Child Protective Act. This measure adds a definition for exigent circumstances and amends the definitions of harm and imminent harm under the Child Protective Act. And first up, we have testimony from the Attorney General.
Good afternoon, Chair Tarnas and members of the committee. I'm Deputy Attorney General Erin Torres. We have submitted testimony in support of this bill, which clarifies the procedures for removing children from unsafe homes and creates a process to engage the family court in making removal decisions that appropriately balance the due process rights of families with the protection of children. The chair of the Senate Committee on Health and Human Services had previously asked for our department's position on amending the definition of harm in HRS Section 587A4 to make it have the same meaning as child abuse or neglect in HRS Section 350-1, and that's in Section 2 of this bill. We do not think that there are constitutional or other legal problems with this amendment, but we also do not believe that it is necessary to link the definition of harm to the definition of child abuse or neglect. We support this bill either with or without that proposed amendment to the definition of harm. Thank you for the opportunity to testify today, and I'm available to answer any questions you may have.
Thank you very much. Next, we have testimony from the Department of Human Services. Kathy Betts, Director. Please proceed on Zoom. If you could unmute yourself, turn on your camera, and present testimony for the Department of Human Services. Okay, we'll come back. Next, we have testimony from the judiciary. Judge Viola, welcome.
Good afternoon, Chair, Vice Chair, and committee members. Matt Viola, Senior Family Court Judge of the First Circuit. Family Court, our written testimony indicated that we're in support of the intent of the bill. We think it's in the current form it's in good shape. Don't think any additional changes need to be made, except we would request that they be an effective date. We had proposed January 1st of 2025. I see in the testimony from the Deputy Attorney or the Attorney General's Office or Department of Human Services asking for an effective date of July 1st of next year. Either one would be fine with us. And I'm available for any questions if you have any.
Thank you, Judge. Appreciate it. Next, we have testimony from the Honolulu Police Department. Welcome, sir.
Good afternoon, Chair. Good afternoon, Vice Chair and members. I'm an acting captain of the Honolulu Police Department, and I stand in support of this bill. And as I've submitted the written testimony, I'm here for any questions.
Thank you very much. Next, we have testimony from the Hawaii Coalition for Child Protective Reform, Nonohe Botello. On Zoom, please proceed.
Aloha, can you hear me?
Yes, we hear you fine. Please proceed.
Thank you. Aloha, my name is Nonohe Botello, and I want to thank you, Chair and Vice Chair, for hearing this measure. It's so important, and thank you for your response to our call, so I appreciate that. As a member of the Hawaii Coalition of Child Protective Reform, we strongly support this intention of SB 2245. HCCRP has worked in collaboration with the Attorney General's Office to draft this measure and to add language that would significantly improve the standard for warrantless child removals. We are also in agreement with the judiciary's recommendations to include language that defines exigent circumstances that means based on specific and articulable evidence. The inclusion of the specific and articulable evidence is critical in determining the standard of warrantless child removals in the state of Hawaii. Currently, we do not have that. We opposed measures last year that did not have that language, but have now come into support this measure because of the amendments that were made. This is long overdue and it needs to be done. Currently, several states under the Ninth Circuit have already codified language into law. The proposed language in this bill is consistent with other state statutes related to exigent removals and children, in addition, SB 2245 allows for some relief under the 14th Amendment of the United States Constitution and Section 5, due process and equal protection under the Hawaii State Constitution. Finally, it's important to note that according to Child Welfare Services report in 2022, the highest rate of removals by ethnicity occurred among Native Hawaiian communities. The highest rate of removals by age were children less than 1 year old, and we're talking about babies. These removals have occurred without specific and articulable evidence and have been subjected to incomplete investigations by CWS and HPD. SB 2245 will help narrow the overly broad scope of warrantless child removals among Native Hawaiians as well as the general population. In closing, I urge your committee to pass Senate Bill 2245 with the effective date of July 31st, 2024. We want to see this immediately effective. Thank you for your time and consideration for this long overdue change in our laws. Mahalo.
Thank you very much. Next, we have testimony from the Hawaii Family Advocacy Group, Joshua Franklin.
Aloha committee, I do thank you for your time today. I am being heard, correct?
Yes, we hear you. Go ahead.
Very good. I'm submitting this testimony in strong support of SB 2245. Particularly from my perspective as a family advocate, I've noticed that many of the families that are impacted by warrantless removals are Native Hawaiian families. I personally have witnessed this in the last, 10 years of working with families that are encountering child welfare services, as well as child welfare services classifying or, creating dispositions where they label a parent an abuser without any kind of proof. This position that I've taken previously with opposing the SB 2245 was because my primary concerns were around the protection and equitable treatment of families under, the framework that was currently written. I have changed my stance with the amendment that was introduced. The requirement for specific and articulable evidence as endorsed by the judiciary is a critical safeguard that's paramount for preventing unwarranted harm to families and ensuring that any legal actions are justified and based on clear, concrete evidence. And so the bill, I stand in strong support of it because it is necessary. This language, unfortunately, is necessary to protect families and children. And it's one step in the right direction in order to reform our current child welfare system to prevent a flooding of children entering our foster care system, especially in cases where they don't need to be there. And so I just thank you all for your time today in hearing this particular bill. And I really ask all of you to support it. It's so critical and necessary. Thank you.
Thank you very much. We've received testimony and support from Karen Worthington. Is the Department of Human Services representative available?
Yes, Chair.
Please go ahead.
Aloha, this is Daisy Hartsfield. I'm the Social Services Division Administrator for the Department of Human Services. I apologize for the technical difficulties earlier. The department did submit testimony in support of this current version of the bill, or current draft of the bill. Similar to the testimony provided today, this has been an issue that has been an issue for a number of years. And through collaborative efforts, this is a draft that I believe all parties are satisfied with. And there is just one recommendation that the department would like the committee to consider, and that is the date of effect should this bill be passed. The department will need time to provide training as well as to work with our partners in the child welfare services so that we can update policies and procedures, and that will take some time. So we're requesting that the effective date be July 1st of 2025. I am available for questionings, and the department stands by its testimony.
Thank you very
Mahalo.
much. Yes, thank you. Next, we have Angela Melody Young with CARES.
Aloha, Chair, Vice Chair, and the committee. Angela Melody Young testifying actually on behalf of Kapalama Neighborhood Security Watch in strong support of Senate Bill 2445. Oh, sorry, I read that wrong, 2245. So the Child Protective Act. So testifying in strong support because the responsibility here, I think, is to distinguish the difference of an exigent circumstance versus imminent harm in an enforceable way, because the police officer has to interpret the situation live in action based on the way the law defines these terms. And there can be consideration also of a training bill or resolution to go along with the new definition. There are technicalities in the law in which it becomes unenforceable. So if you look at page 2, chapter 5878-8, protective custody by police officers without court order. A police officer shall assume and determine if this child is subject to imminent harm. The police officer is making the decisions. And when we look at page 1, line 5, definitions of exigent circumstances, this is about when a police officer has to take away a child based on exigent circumstances, this new definition of harm, versus the old definition, imminent harm, right? So imminent harm did not require an action prior to this bill. Now we have a new level of extreme and serious level of harm, and it requires action, exigent circumstances. And based on this new statutory definition, this child must be taken away.
Please summarize.
My point is you have to consider the training of the police if they are trained to act, if they have a strategy to recognize how to implement the law. If imminent harm means screaming and yelling at the park, and exigent circumstance is when screaming and yelling escalates to domestic violence. Thank you.
Thank you very much. And we received testimony and support in writing from 6 individuals. Is there anyone else here or on Zoom wishing to testify on Senate Bill 2245? If
I would
not-
like to testify.
Oh, yes, please proceed. Introduce yourself. Go ahead.
Aloha, thank you. Can you hear me?
Yes, we hear you. Please
Uh,
proceed.
Okay, I would just like to also testify in support for this bill. I didn't submit written testimony, but I believe that this is a great thing for our state. And I highly support all the individual testimony. And thank you for hearing me and allowing me to submit testimony orally.
Thank you very much for your testimony. If you want to send anything in writing, please do so. But otherwise, anyone else on Zoom or in the room wanting to testify on Senate Bill 2245? If not, questions, members? I have a question for, let me start with the Department of Human Services. Do we need to define the term serious harm?
I'm actually going to defer to the Attorney General's.
Okay.
In regards to that.
All right.
Thank you.
I ask the Attorney General, do we need to define serious harm?
It's funny because in response to that question, I think I would want to defer to the Department of
Okay.
Human Services. It's really a question of the police and the responding DHS workers' interpretation of the definition of exigent circumstances, which, as you're pointing out, does include a consideration for serious harm. Yes.
So you don't know for sure?
I don't, in my previous discussions with DHS, it didn't seem that was necessary.
Okay.
But that was a while ago, so I'm not sure what the current.
Sounds like they're not asking for it or anything. It's just something that our team, our staff has identified. And the other question is, the amendments made to the definitions of harm and imminent harm seems like they could have an impact on how the term abused or neglected is defined in Chapter 346. Do we need to be, is that intentional, or do you know?
I believe your, I believe the question is the linking of the definition of harm in Chapter 587A to the definition of child abuse or neglect in Chapter 350? Is
Oh.
that what you're asking about?
I thought, I had it in 346, but,
It's in 350-1.
okay. So you're comfortable with the way it's constructed right now?
We're comfortable with the way that it's constructed. We don't see any legal or constitutional problems with it.
Okay.
It was a question that was raised by Senator San Buenaventura
Okay.
early in this legislative session. So we are very supportive of this bill. We would really like it to pass. The definition, specific definition of harm or amending it, we believe is not crucial to the passage of the bill with the
Okay.
intent.
Okay, great, thank you very much,
you.
appreciate it. Any other questions? Nope, okay, let's move on to the next measure. Senate Bill 2560, Senate Draft 2, House Draft 1, relating to invasive species. This measure provides that each lease that the Department of Agriculture enters into, renews, or extends shall authorize the Department of Agriculture to enter the leased premises with prior notification to survey for, identify, investigate, control, or eradicate pests, work cooperatively with the lessee to seek funding and develop a plan to maintain control of any pests on the leased premises, and terminate the lease if the lessee refuses the DOA entry or refuses to work cooperatively toward the control or eradication of pests. First up, we have the Department of Agriculture. Welcome, Chair Hurd.
Good afternoon, Chair, Vice Chair, Member. Sharon Hurd, Department of Agriculture. The department stands on our submitted testimony with the comment that this measure might be unnecessary as these provisions already exist in the leases that we issue, and the clause to terminate regarding termination of the lease is already a duty of the Board of Agriculture when that is presented to them for consideration. Thank you for the opportunity.
If I may ask, your
Yeah.
last paragraph says that if we decide to move it forward, you've got a suggestion? The
We-
definition of
we
pest
don't-
match the existing one in HRS 150A-2?
That would help. Otherwise, the definition is not clear, so we should use the list of pests that is already accepted as a pest.
So you're just saying that the definition of pest, we should use the one that's in HRS 150A-2?
Yes.
Okay.
Okay?
Okay, thank you.
Thank you.
Next, we have testimony from Christy Martin, Program Manager, Coordinating Group on Alien Pest Species. Welcome. Please proceed.
Aloha malo. Thank you, Chair Tarnas, Vice Chair Takayama, members of the committee. Christy Martin, Coordinating Group on Alien Pest Species, CGAPS. We have very similar comments to the Department of Agriculture. We appreciate the existing language that they already use in their general lease. And in fact, the lessee shall immediately notify the lessor, Department of Ag, if there are any suspected or known invasive species already on the land or nearby the land. And in fact, this House Draft 1 would actually prohibit Department of Ag from continuing to use this general lease that already has this excellent language in it. And instead, it would merely authorize the department to, quote, work cooperatively with the lessee to seek funding. And that significantly reduces our ability to manage invasive species. Their existing lease is 99% of the way there, and passing this bill would actually harm their ability to use that. We do have some suggested language. It's in our written testimony. In the interest of time, happy to answer questions. Mahalo.
Great, thanks very much. And we have testimony and support from the Hawaii Farm Bureau, comments from the Hawaii Cattlemen's Council, and support from Carol Kwan. Is there anyone else wishing to testify on Senate Bill 2560? Go ahead, Ms. Young.
Aloha. Committee, Angela Melody Young, testifying on behalf of ROAR, Rescue of Animal Rights. So it's very important to set forth measures to deal with invasive species. And as per this act, as the lease that is in the act will be investigated to deal with invasive species. So I'm going to rationalize my support for this bill because of the action plan set forth by prior appropriations of funds for biosecurity to manage invasive species. Biosecurity involves restricting the movement of species capable of carrying harmful agents of illness. And within the broad framework of dealing with invasive species from NOAA, the National Oceanic Atmospheric Administration, it defines invasive species as species that cause detrimental environmental and economic effects. It causes fundamental disruptions to the biodiversity of life. And so our concern is that there should be more regulatory measures and provisions by law to set forth the parameters to deal with invasive species.
Thank you very much. Anyone else wishing to testify on this measure? We have on Senate Bill 2560. Anyone else? If not, questions, members? If I could ask Department of Ag, just to make it very clear. So your opinion is that this bill is unnecessary because your existing lease takes care of what you believe are the necessary things in regard to dealing with invasive species?
Respectfully, yes, and Representative, it would be a duplication of what is already in our lease.
Okay.
So it would just be redundant.
Okay.
Okay?
Okay, thank you.
Thank you.
Thanks very much. All right, thank you to all the testifiers. Appreciate that. Okay, let's move on to the next measure. Senate Bill 3122, Senate Draft 1, House Draft 1, relating to public health standing orders. This measure authorizes the Department of Health to issue public health standing orders for patients to self-refer to certain healthcare screening services. It establishes requirements for the provision of items or services pursuant to a public health standing order and establishes the Public Health Standing Orders Working Group. First up, we have the Department of Health.
Good afternoon, Chair, Vice Chair, members of the committee. Lauren Kim, I'm the Planning and Policy Officer for DOH. The department strongly supports this administrative measure, and we are very grateful for this committee and the legislature for moving this through and ask that this be passed along to conference. This bill is both aspirational and operational. So let me start by defining a standing order. We're surrounded by standing orders. They are a way to increase access to healthcare services and reducing the administrative burden on healthcare workers. For example, if a family walks in to a medical clinic and they see in the child's record that they haven't got their vaccinations, a medical assistant or a nurse can order those vaccinations without having to go to a physician and review the file and do all those sorts of things. So standing orders are based on evidence-based guidelines that are very clear, have been well-researched, and have received the highest levels of scrutiny from healthcare. And in fact, the recommendations that we are proposing for the public health standing order are United States Preventive Services Task Force recommendations A and B, which means they have the highest benefits to patients at the lowest risks. So what this measure, the aspirational part of this, is to improve equitable access to healthcare services, decrease the healthcare workforce burden, improve customer convenience or patient convenience, and help everybody live longer, more healthy lives. So simple, right? So that's our aspiration. Operationally, this can't be done without the cooperation of industry stakeholders, and thus there is a working group that will guide the Department of Health as equal partners and stakeholders in implementing them, on what schedule, what order we should take them in, because every one of these recommendations is a rabbit hole in and of itself in terms of education, of administrative processes, but it's something that, with the cooperation of industry, we think is worth our time and effort to try to improve our healthcare system, starting with some what we think are low-hanging fruit, but which aren't necessarily simple, but they are low-hanging. So thank you for the opportunity to testify, and I'm available for questions.
Thank you very much. Next, we have testimony from the Hawaii Association of Health Plans. Rachel Wilkinson? No. In support. Next, we have testimony from HMSA in support.
Aloha, Chair Tarnas, Vice Chair Takayama, Representative Miyake. Thank you for allowing us to, Walden, on behalf of HMSA, to testify in support of this bill. We appreciate the intent of the department, and we look forward to the continued discussion through the working group that will take place in the interim should the bill pass. Thank you.
Thank you very much. And next, testimony from Aloha Care.
Aloha Chair, Vice Chair, members of the committee, Mike Nguyen with Aloha Care. We'll generally stand on our written testimony, just want to underscore a couple of points. We do support this measure as a means of improving access to care, and given our provider shortages across the state, this would also help to reduce administrative burden, as DOA shared. We would like to thank Department of Health for working with Aloha Care and also other stakeholders on amendments taken in the HD1 version. As summarized, the amendments help to ensure that patients make informed decisions about accessing services. They also help to ensure that patients are connected to their primary care provider, and we're also very supportive of the working group to make sure the implementation is smooth and thoughtful. So thank you for this opportunity to testify.
Thank you very much. Next, we have testimony and support from the Hawaii Health and Harm Reduction Center, from Hawaii Pacific Health, Hawaii Public Health Institute, HEP Free Hawaii, and we have testimony and support from 5 individuals and one individual in opposition. Is there anyone else wishing to testify in Senate Bill 3122? Please proceed.
Aloha, Angela Melody Young, testifying in strong support of Senate Bill 3122. So the purpose of this act is to reduce
You know
burdens.
what the purpose of the act is?
To
Please
healthcare
just tell
access.
us your opinion.
Okay, so the act will create access, right, to the screenings of the medical diagnostic procedures listed in the United States Preventative Services Task Force, which is from a federal act, the Affordable Care Act. Okay, and the diagnostic procedures or medical care interventions can include screening for anxiety disorders in pregnant and postpartum mothers, screening for behavioral counseling for all sexually active adolescents, and for adults at increased risk for sexually transmitted illnesses, screening for anxiety in adolescents 8 to 18 years old, screening for asymptomatic bacteria using urine culture in pregnant persons, behavior intervention for smokers, behavioral health counseling for alcoholics, intensive multi-component behavior interventions for obesity. And then also there are a few other very common medical care interventions and diagnostic procedures not covered by this list within the task force, such as like stroke screening. So,
Would you please summarize?
you know, the health disparities are very important to address by policy. So in advancing the health equity, leveling out the playing field to eliminate barriers, I think it's just so critically important to get this priority enacted as a law.
Thank you very much. Anyone else wishing to testify on Senate Bill 3122? If not, questions, members? No, thank you. Let's move on to the next measure. Senate Bill 3125, Senate Draft 2, House Draft 1, relating to medical care for minors. This measure authorizes minors who are 14 years of age or older to consent to medical care and services for sexually transmitted infections, pregnancy, and family planning services, including the prevention of sexually transmitted infections. It requires confidentiality policies and practices for insurers and healthcare providers. First up, we have the Department of Health.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and Representative Miyake. The Department of Health, I'm Tim McCormick on behalf of the Department of Health. The Department of Health stands in strong support of this bill. We stand on a written testimony, but I just wanted to underscore that this bill addresses a gap in the existing statute whereby a minor 14 to 17 is able to to consent to medical services if they have HIV or a sexually transmitted infection, but the current statute does not permit them to consent to medical services for the prevention of HIV or sexually transmitted infections. And that gap really was created with the advent of medication, which is highly effective in preventing HIV when taken prior to exposure. So I'm available for any questions you may have and appreciate the opportunity to testify.
Thanks very much. Next, we have testimony and support from the Disability and Communication Access Board. Next, we have testimony from Parents and Children Together. Trish Kajimura, welcome. Please proceed.
Thank you. Good afternoon, Chair Tarnas, Vice Chair Takayama, and Representative Miyake. My name is Trisha Kajimura with Parents and Children Together. We're a statewide social services agency originally founded in Kalihi. We support this bill because we serve youth in this age group in several of our programs, and we want all youth to have access to life-saving medical care. Currently, not all youth have the ability to speak safely and constructively with a parent or guardian about their sexual health, and it's really those youth that will be assisted by this bill. And we want that equity for everyone. Thank you.
Thank you very much. Next, we have testimony from the Hawaii Federation of Republican Women. Jamie Detweiler, please proceed.
Aloha. Aloha, Chair Tarnas, Vice Chair Takayama, members of the committee. Thank you for this opportunity to testify. Hawaii Federation of Republican Women, we stand in strong opposition of SB 3125 SD2 HD1 for the following reasons. Excuse me. Number one, young minors, any age of minors below the age of 18 do not have the capacity to make safe and sound decisions, understanding the pros and cons, and as well as the consequences that come along with decisions such as having to take medications. And so we all know that our prefrontal cortex of the brain is not fully developed until well into our 20s. So there's that lack of capacity along with safety risk concerns. The other thing, I want to take the time to thank the authors for including in the bill the education piece of prevention of sexually transmitted diseases. I think so often that piece is overlooked. So I want to give a nod to the authors of the bill for including that. My other concern includes there's a propensity for increased criminality by passing this law, and I'll give you some examples. So we know child human trafficking, child sex trafficking is real. It even exists in Hawaii. And what this bill will do is will allow quote unquote pimps to direct their underage, their minor sexually active victims in their employ, force them to get these services, including abortions, which was already codified in SB1 last year, but this increases that risk for abuse by the criminals in Hawaii. Additionally, passage of this bill into law will invite out-of-state pimps to conduct business in Hawaii. This is dangerous for children all over the world and the nation. And lastly, part of prevention and treatment too is including family in this decision. And, working with the child to encourage conversations, difficult conversations with their parents. And as a licensed social worker, I know this is an area that is challenging for both youth and their family members. But I want to leave you with these questions to ponder on in your decision-making process. Healthcare decisions by minors should include parental notification. How can parents best help their child heal from sexually transmitted diseases if they're kept out of the process? And shouldn't we be helping parents have discussions with their children to ensure that they have the best care? Laws should not be created that establish a wedge between children and their parents. And
Thank you very much.
For these reasons, I would like you to vote no on this bill. Thank you.
Thank you very much. Appreciate it. Next, we have testimony from the Stonewall Caucus of the Democratic Party of Hawaii, Michael Goluch. Next, we have testimony The next person who said they want to give testimony is Gary Cordery. Next, Mary Healy.
Hello, thank you, committee and chair for listening to my testimony. I strongly oppose Senate Bill 3125. Minors receiving medical care for pregnancies, sexually transmitted infections, or family planning services must still require a parent and guardian or spouse's consent. The bill removes parental, guardian, and spousal rights, and by circumventing these rights, endangers the minor. In Hawaii, 16 is the legal age to marry with parental consent, and only certain circumstances 15-year-olds may obtain a license. But no one under the age of 15 may get married in the state of Hawaii. The legal age to buy alcohol and tobacco products is 21 years of age in the state of Hawaii. And to obtain a 329 medical marijuana card, the patient must be 18 years of age or suffering from one of the qualifying health conditions with one or more parents willing to act as a caregiver or with a nominated caregiver. By removing these parties' rights to know what is happening to the minor, the bill aids in the exploitation of minors, which includes but is not limited to child sex trafficking, which often uses coercive means to control victims. Senate Bill 3125 endangers the minor. This bill not only endangers the minor, it endangers Hawaii's unborn, our most vulnerable individuals, by not offering counseling or disclosure to the parties who would be most adequately prepared to help the minor and would be normally informed. So I ask you to vote no on this bill, and thank you for listening to my testimony.
Thank you very much. And the last person that said they want to testify is Keikoa Kealoha.
Hi, aloha Chair Tarnas and committee members. Thank you very much for the ability to, or for the opportunity to speak here today. I have submitted written testimony. I really hope that you take the time to consider that. I really want to drive home a couple of points. I have real world experience working with people who are living with HIV. I've worked directly with over 200 people living with HIV, both here on Oahu and on Hawaii Island. I have also worked with several hundred more people who are at risk for HIV and other STIs in my capacity as an HIV and STI testing counselor. And I have also worked very closely with human trafficking victims and case managers and other community partners, and with extensive experience in that. And my experience has shown me that the people who are most vulnerable and the people who need this bill the most are the ones who don't have parents who are involved in their decision making. Right now, our reality punishes minors who cannot have safe conversations with their parents about things like HIV and STIs. And it is really a shame if we are not protecting them because they are the most vulnerable among us. My experience has also shown me that the parents and the family members who want to be involved in their child's care already are. And that's in spite of what our current laws are. And it's a beautiful thing when you see parents who are involved in their children's care. Unfortunately, I am very familiar with the flip side of that and what it looks like when parents and family members are not supportive of their children's health care and healthful decision making, and very often they tend to have the worst outcomes. And so I strongly urge you to vote in support of this bill to help protect minors who have no other means to protect themselves. Mahalo.
Thank you very much. Is there anyone else wishing to testify on this measure? Senate Bill 3125, Senate Draft 2, House Draft 1. Please proceed.
Angela Melody Young, testifying on behalf of CARES. In strong support, but my major concern with this bill is the privacy law. As per the HIPAA Act, which is a federal act to set standards about privacy, it is not legislated in the bill in front of us to protect minors, although it does refer to in the bill we will consider privacy laws, right? So the HIPAA privacy rules creates national standards to protect medical records and identifiable health information. It does set a limit and condition on the uses and disclosures that may be made of such information without authorization. The privacy rule is located in Chapter 45, Code of Federal Regulations, Part 160 and subparts A and E of Part 164, it provides the first comprehensive federal protections for the privacy of health information. And this concern is very practical. Why protecting minor information is so essential, okay, I will go into these next few points. In an article called The Growing Epidemic of Sexually Transmitted Illnesses in Adolescents, a Neglected Population, it says epidemiology is used in examining sexually transmitted illnesses in adolescents. What is epidemiology? Right? Okay, so epidemiological information is used to plan and evaluate strategies to prevent illnesses, and it is a tool for the management of public health. Epidemiology is the study and analysis of the distribution, patterns, and determinants of health and illnesses in a defined population to advise health policy.
Please summarize.
So if there is epidemiology information that is being used in examining minors in their healthcare process, it needs to be protected
Thank you.
by the HIPAA Privacy Act.
Thank you very much. Appreciate that testimony. Anyone else wishing to testify on this measure? If not, questions, members? Seeing none, thank you very much. We'll move on to the last measure on our hearing today. Senate Bill 2354, Senate Draft 1, relating to alcohol. This measure expands the definition of beer under the intoxicating liquor law to mean any alcoholic beverage containing not less than 0.5% alcohol by volume, obtained by fermentation of any infusion or decoction of malt or any substitute, including alcohol, seltzer beverages, and excluding sake, cooler beverages, and other distilled products. Authorizes brew pubs to sell beer they manufacture or beer manufactured on their premises, subject to certain conditions. First up, we have testimony from Kona Brewing, Hawaii, in support. Testimony from Hawaii Public Health Institute. And Ms. Angela Young. You want to testify? Your name is on here.
Actually, I'm not going to testify.
Okay. Appreciate that you'll hold off on your testimony if you haven't read the bill. Anyone else wishing to give testimony? Mr. Yosua?
Thank you, Chair, members of the committee. Mike Yosua on behalf of Anheuser-Busch. We're in support of this bill moving as is with the current definition and exclusions. We think it's a good bill for the craft breweries, local craft breweries, and strong support. Thank you.
Thank you, Mr. Yosua. Anyone else wishing to testify on this measure? If not, questions, members? If not, thank you very much. We have quorum, so let's move on to decision-making. Up to the top of the agenda. Senate Bill 2245, Senate Draft 1, House Draft 1. I would like to recommend that we move this out with technical amendments and put in an effective date of July 1st, 2025. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 2245 SD1 HD2. Chair and Vice Chair vote aye. Representative Evelyn?
Aye.
Representative Ganadin?
Aye.
Representative Holt? Aye. Representative Ichiyama excused. Oh, my apologies. Representative Iligan excused. Representative Kong?
Aye.
Representative Miyake?
Aye.
Representative Iligan?
Aye.
Representative Souza excused. Chair, your recommendation is adopted.
Thank you very much. Next, Senate Bill 2560, Senate Draft 2, House Draft 1. You know, I heard loud and clear from the Department of Agriculture that this bill is not necessary. I've been asked to move the bill forward, but I will retain the defective date because we'll continue the discussions because we may not need the bill and we may not have it come out of conference committee. But I've been asked to move it forward. I'd like to, page 2, line 3, just change restricted or prohibited species, that term, and change it to prohibited or restricted organism. See sections 150A-52 and 150A-53. And I would like to adopt the Department of Agriculture's amendment, the definition of pest, to match the one in HRS 150A-2. Those are my recommended amendments. We'll keep the defective date. Questions or concerns, members? If Not, Vice Chair for the vote.
Voting on SB 2560, SD2, HD2, noting the excused absence of Representative Souza. Any members voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you. Senate Bill 3122, Senate Draft 1, House Draft 1. I recommend we move this out with technical amendments and put in an effective date of July 1st, 2024. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on SB 3122, SD1, HD2, noting the excuse. Any members voting with reservations or no? With reservations. Reservations for Representative Kong. Your recommendation is adopted.
Thank you. Next, Senate Bill 3125, Senate Draft 2, House Draft 1, relating to medical care for minors. On this, members, I recommend we move it out with technical amendments and with an effective date of January 1st, 2025. Questions or concerns, members? Representative Ganadin.
I'd like to thank the medical professionals and advocates that work with marginalized communities, especially youth and parents of children and children together who showed up here today, who do that work in the community that I get to represent in essentially saving lives. I think that this bill has become unnecessarily part of a partisan political agenda to discuss parental rights when it really is about saving human lives and saving young people's lives. So my thanks go out to your work and your continued work. I'll be voting yes.
Thank you for your comments. Anyone else wishing to comment or any questions? If not, Vice Chair for the vote.
Voting on SB 3125, SD2, HD2. Any members with reservations or no? No vote. No vote for Representative Kong. Chair, your recommendation is adopted.
Thank you. Final bill, Senate Bill 2354, Senate Draft 1, relating to alcohol. I recommend, members, that we move this out as is. Questions or concerns, members?
Are there any samples? What a guess.
Any other comments? If not, Vice Chair for the vote.
Voting on SB 2354, SD1, passing with passing as is. Any reservations or no? Seeing none, your recommendation is adopted.
Thank you very much. There being no further business before this committee, we are adjourned.